Our next panelist is Pamela Price. Pamela Price is a nationally recognized pioneer in employment discrimination and civil rights cases. Attorney Price regularly wins difficult cases of sexual harassment, racial harassment, and discrimination in federal and state courts. She also won a case or two in front of the U.S. Supreme Court. Her legal advocacy for women stems from her own experience as a survivor of sexual harassment, sexual assault, and domestic violence. I give you attorney Pamela Price.
Thank you, Kathy. And thank you all for having me. I am honored to be a member of the Coalition for Police Accountability and to have represented the coalition in a federal lawsuit where we attempted to bring the community's voice into the long-standing, overdue consent decree that no longer seems to serve its purpose for the most part. I'm also a member of Our Revolution East Bay and have been proudly endorsed by that organization in my quest to advance the mission of reforming the criminal justice system in Alameda County. So I'm honored to be here. Thank you. I want to talk about from a historical perspective, the evolution of criminal justice in California. And as I shared with our host, in planning this town hall, I have had a bird's eye seat, unfortunately, in the expansion of the prison industrial complex in California. My first understanding of the prison industrial complex and the inhumanity of incarceration in America is both my own juvenile experiences. I'm a survivor of the Ohio juvenile justice and foster care system. But I was blessed to go to Yale College. And in 1975, we hosted an event at the Yale Law School called Yale Attica Weekend for Life. And we brought to the Yale Law School the lawyers who were representing the prisoners and the families of those who suffered during the Attica State Prison uprising in New York State, which still stands today as the largest prison uprising in the history of the United States. And so I got to hear those stories firsthand and to see those lawyers standing in the gap for those families and for those who had suffered terribly and been the subject of the state assault upon the prisoners and those who were inside the prison on that day, terrible day of inhumanity. Then came to California and went to law school. And I want to kind of put this in context. California entered the Union in 1850. And it is ironic that in 1852, California legislature passed the California Fugitive Slave Act, which allowed enslaved and escaped slaves to be captured and returned to slavery anywhere in the United States, including California, because many people were brought to California as slaves and escaped. But under the legislation in 1852, we had our own Fugitive Slave Act. Not surprisingly, in 1852, California opened its first major state prison, San Quentin State Prison, which was built by prisoners. But now we have that institution, which remains, as many of us know today, open still and houses California's death row. Fast forward from the 1850s to 1976, which we consider the modern era of criminal justice. And in 1976, California the legislature passed Senate Bill 42, which enacted something called determinate sentencing. And determinate sentencing has been recognized as the driver of the explosion in the California prison population. California prison population has increased 900% since 1976. And it's largely due to the determinate sentencing, which clearly said for the purpose of imprisonment in California for crime is punishment. There was no investment to be in rehabilitation and no thought about rehabilitation. I happen to have been admitted to practice law in California in 1983, and was honored to be able to participate in, from that point on, as an advocate against the criminal justice system. I started my legal career in Bayview Hunters Point Community Defender's Office, representing people charged with crime in San Francisco. It was a federally funded program, one of the few in the country. Well, there were many at that time. It survived for many years, but ultimately federal funding was taken away for those kinds of programs. Ironically, between 1980, I left Bayview Hunters Point in 1984. Between 1984 and 2005, California built 21 prisons. And I want to take you quickly through some of those significant developments. In 1984, we built CSP Solano. It was designed for 2,610 prisoners, and currently it holds 3,752 prisons. That prison at one point, and even today, is at 144% capacity. In 1986, we built CSP Sacramento, which was designed for some 1,800 prisoners, and then ultimately held over 2,300. So it stands at 129% capacity. 1987, we built Avenal State Prison, which was designed for 2,920 prisoners, and it currently holds 4,197 prisons. It's at 144%. Mule Creek State Prison was built in 1987. It was designed for 3,284 prisoners, and it currently holds 3,948 prisoners, 120% over capacity. Corcoran State Prison, many of you may have heard of this, is a super max prison. It was designed to hold 3,116 prisons. It currently holds 3,719 prisoners, so it's 114% over capacity. 1988, Chuckawalla State Prison was designed to hold 1,738 people. It currently holds 2,324 people. It's at 134% capacity. In 1989, Pelican Bay State Prison was opened. It includes 1,000 secured housing isolation cells. It was designed to hold 2,380 prisoners. It currently holds 2,608 prisoners, so it's at 110% capacity. In my practice, I opened my own practice in 1991, and I was privileged to take 3 cases in that first year. One, sexual harassment, Polito versus CDC, a sexual harassment case on behalf of a female officer at San Quentin State Prison. Those first 3 cases were all at San Quentin. I then represented, in short order, Doug Hines, the chapter president for the officers union there, who took on the issue of racial disparities in discipline, pointing out that African American officers were being disciplined at significantly higher rates than white officers or Latino officers. And as a result, Doug Hines was set up to be killed inside San Quentin. So he almost paid with his life for having the audacity to both document it with the help of another Black officer, as well as then challenge the prison administration to do something about it. Ultimately, Doug was drummed out of the union for being a troublemaker. Then I also represented Lynn Atkinson. This was a retaliation case based on not her politics. She just did her job. She was the counselor who said that Geronimo Pratt was wrongfully imprisoned and was a political prisoner. And for that, she paid with her career. She investigated Geronimo Pratt's case, and she wrote a report as a correctional counselor and submitted the report that said Geronimo Pratt is a political prisoner and he should be released. I don't believe he committed the crime. That cost her her career and almost her life. So I was honored to represent those people who were employed within the California Department of Corrections, but who in their own way were standing up to make California a better place, who were fighting oppression on the inside, and they needed an advocate. That was the first of many cases. I spent the next 25 years suing the Department of Corrections. And I'll never forget the day that I took the deposition of one of the experts in one of my cases who had been hired and designated by the department as an expert. And as I listened to this man talk about his career within the Department of Corrections and the things that he had done in terms of designing prisons, and all the prisons, as he went through the list of all the prisons that he had designed and that he had helped open, and how proud he was. I literally had to take a break in the deposition, and I walked out of there feeling like I am in the room with Dr. Frankenstein, because this was the man who had created and fathered mass incarceration in California. In 1991, the same year that I opened my practice and started suing CDCR, we opened Wasco State Prison, which was designed for 2,984 people and currently holds 4,121 people. It's at 138% capacity. In 1994, California passed Proposition 184, the three strikes law, that doubled felony sentences and mandated 25-year to life sentences. And one thing we know that we learned from the 1976 determinate sentences, if you build prisons and you create mechanisms to incarcerate people, judges and district attorneys will fill the prisons. And that's exactly what happened. So when I talk about overcapacity, understand that what that means is that these prisons became instantly, and that's one of the things the gentleman in that deposition talked about. He talked about how they would build the prison he designed it for this many people, and within overnight, these prisons were overcrowded. That means you couldn't get medical care. You did not have, you were housed in a place that was significantly overburdened with a lack of services, a lack of housing, the kinds of things that ultimately become death sentences for people inside our prisons. In 1995, a watershed moment, Judge Stelton Henderson ruled in a case called Plata v. Brown that CDCR's medical care inside the prisons was unconstitutional, and he ordered the state prison medical system to go into receivership. The evidence that was put together largely by the prison law office demonstrated clearly that in these overcrowded prisons, we were not providing medical care to people, and people were dying. That was a significant moment, but it took another 10 years for the state to for the receivership to actually go into effect. And in that time, in 1994, we built Pleasant Valley State Prison, designed to hold 2,308 people, and it currently holds 3,062 people, 133% over capacity. Ironwood State Prison, designed to hold 2,200 people, but currently holds 3,203 people, 146% above capacity. High Desert State Prison, designed to hold 2,324 people and holds currently 3,286 people, 141% above capacity. Valley State Prison, designed to hold 1,980 people and currently holds 2,971 people, 150% above capacity. Salinas Valley State Prison, designed to hold 2,452 people and currently holds 2,877 people. It's 117% over capacity. And again, when you're talking about institutions, cells, iron, stone prisons that are over capacity, there's not enough staff, there's not enough services, there's not enough resources. I've been to many of these prisons. I've been to Mule Creek, I've been to High Desert, I've been to Corcoran and Pelican Bay. These places are cold, they're built in places, they're like stone cages. They look often from places like they're from the Stone Age. Pelican Bay is a hell of a place. I was forced to go inside because of one of my cases, and I went inside the control booth and I went inside the SHU unit. These places are terrible, and yet they're overwhelmed by the lack of resources. I mean, so just in and of themselves, they're terrible. But when you think about their over capacity from day one, they're not safe, they're not sterile. No, these are horrible places. And so the receivership that Judge Henderson ordered in 1994, 1995, CDCR fought that all the way to the United States Supreme Court, and it took 10 years. In 2003, Governor Arnold Schwarzenegger renamed CDC to become CDCR. And before I leave the 1990s, understand the context in which California was building all of these prisons. You had the super predator mythology that was evoked nationally in the 1990s, approximately 1996. You had the Central Park Five, which epitomized the targeting of young Black children. So you had youth who were being prosecuted as adults across the state of California and sent to these horrible places. Okay, you had people that were receiving felony sentences and sentence enhancements, mandatory sentences, 3-strike sentences. All of that was happening. And those of us who watched it with horror just had no place to go with it. In 2006, California's prison population peaked at 173,000 people. The system was designed to house 85,000 people. So we were at 204% above capacity. Think about that. Think about that. Okay. Finally, in 2006, the receivership that Judge Henderson ordered in 1995 actually began. And medical care, there began a process of trying to make sure that medical care was being provided. And that was just the tip of the iceberg. It took another 5 years of CDCR appealing all the way to the United States Supreme Court before the United States Supreme Court in Brown versus Blatter declared that imprisonment in California was unconstitutional, that it violated the conditions of confinement, violated the Eighth Amendment's prohibition against cruel and unusual punishment. So in 2011, under the burden of litigation and lawyers, and finally court decisions finding our entire prison system unconstitutional, the legislature responded with AB 109, which began a process known as realignment, whereby under the statute, non-serious, non-violent, non-sex convictions and people convicted of those particular kinds of violations were sentenced to serve in their sentences in the county jails. As a result of realignment, the county jail budget, typically the sheriff's budgets throughout the state of California, they began to receive millions of dollars, and our county jail populations increased. And we weren't ready for it. And we have no control, no oversight over most county jail facilities. California has 56 county jails run by county sheriffs who are elected by the people and basically run every county sheriff runs his domain like a fiefdom, much like what I found with the prisons, that every warden considered himself the king, and he was the king, and everybody bowed down to the warden. And in every California county, everybody bows down to the sheriff. And in Alameda County, we saw the horrible, horrible administration of justice by our county sheriff. And in particular, Alameda County is a classic example of the failure of the criminal reform, justice reform movement that was ushered in, at least initially in 2011, by realignment. Last year, or in 2018, an Alameda County sheriff was charged with eavesdropping for illegal illegally recording conversations between detained juveniles and their lawyers. The practice is suspected to have occurred with respect to adult conversations. So the right to counsel was being routinely violated in Alameda County Jail. Alameda County has one of the highest rates of inmate deaths in California. 35 people had died in Alameda County Jail in Santa Rita since 2014. 29 civil suits filed against the Alameda County Jail Administration, including a pregnant woman who was forced to give birth alone in a dirty cell while the deputies ignored her screams, and then suddenly the baby was born. Since 2015, the Alameda County Sheriff's Office has been sued and racked up more than $15 million in settlements and judgments in civil rights cases. So this is how we are now administering justice in California. The statutes have changed. We are on the cusp of huge realignment in terms of criminal justice reform. The problems exist, but in 2012, the voters of California passed Prop 36 to modify the three strikes law. In 2013, the prisoners at Pelican Bay began the longest hunger strike in protest of solitary confinement and isolation. In 2014, the voters passed Prop 47 to reduce felonies to misdemeanors. In 2016, we passed Prop 57 to mandate parole for nonviolent offenders and to limit the district attorney's ability to charge juveniles as adults. In Proposition 64, we legalized marijuana and gave the DA's authority to resentence or dismiss marijuana convictions. Proposition 2018 was a watershed year as well in criminal justice reform, passing of legislation to allow resentencing, to stop juvenile prosecution as adults by district attorneys, to eliminate enhancements, and to open up police files with SB 1421, which allows us now access to police records. CDCR currently houses 117 inmates in 35 prisons. It constitutes over 7% of our state budget. We still have much work to do, and much of the fight is now shifted to the counties. And so I urge everyone to look at what is happening in our county, with the sheriff's department, in the local facilities, as we continue the battle against incarceration in California. Thank you for having me. Thank you.
That was great. Wonderful history of California too.
Yes.
Seeing exactly how everything stacks up and basically hurts everyone except for the powerful.